On the slopes of Diamond Head, this is Kapiolani Community College. Kulia Ikanu'u, strive for the highest.
Aloha. Welcome to BLAW200, Legal Environment of Business. I'm Ben Carroll. Well, last time we took a look at administrative agencies, a little bit of regulation, and today we're going to get into the consumer safety, consumer health, consumer protection area. So we'll kind of wrap up our look at legislation. This is an area that has a lot of administrative law, which we talked about last session. But first, let's take a look at what we covered last time. Make sure you've got that in your memory banks. Why do some people refer to administrative agencies as the fourth branch of government? Okay, well, we've spent quite a bit of time in these sessions with the three branches. So we've got the executive branch, which has departments and agencies, executive orders. We have the legislative branch, which creates statutes, and we have the judiciary, which interprets them all through common law and case law. And we have some people that would refer to the administrative area, the departments and agencies, as a fourth branch, even though they're housed, for the most part, in the executive branch. Now, why would they do that? Well, it's because of the unique status of a lot of these departments and agencies where they do have a lot of power that seems to incorporate the powers of the other branches. So, in a sense, they have the legislative power in their rulemaking. They have the judicial power when they interpret the rules and issue decisions, and they have the enforcement power. So that's one reason that this whole area has been considered, to some degree, a separate area, a very powerful area. Okay, what is enabling legislation in administrative law, and what is covered by the Administrative Procedure Act? Well, as we said, these are powerful agencies, but they do get their authority from the legislature. So the Constitution gives the legislature the power to make law, and in turn, the legislature can delegate some of this power to the departments and agencies, which it does through the Enabling Act. We also sometimes refer to that as the Authority Statute or the Authority Act. So this is where the legislature is enabling the department or agency, giving it its power, telling it what it is that it can do with respect to enforcing a particular statute. Now, the Administrative Procedure Act is another statute that covers how departments and agencies operate. So remember, the Enabling Act is specific to that department or agency. In other words, it is unique to that, giving a certain power over a certain legal area to that department or agency. But the Procedure Act is defining kind of the minimal level of due process and procedural safeguards that every department and agency must follow. So each agency would have to follow its own Enabling Act, and it would also have to follow the Procedure Act. So there's a Federal Administrative Procedure Act, and most states will have it. Many will call it their Administrative Procedure Act. For example, HAPA, the Hawaii Administrative Procedure Act. And that will cover the entire range of what the agency does. So it will explain how the agency is to create rules and regulations. They have to have a public hearing so that, or public notice so that people have an opportunity to respond. It tells that they have to give notice if they're having a hearing, whether evidence can be presented, that sort of thing. Now again, each department and agency can make its own rules and regulations as long as they are in accordance with the Enabling Act and the Procedure Act. But the Procedure Act gives kind of the basics, the structure, the required structure for all departments and agencies. Okay, what does exhaustion of remedies mean, and why is this important? Are there exceptions? Well, exhaustion of remedies is sometimes called exhaustion of administrative remedies, and that's what we're talking about. So this means that a person who is in front of an agency needs to go through their procedures until a final decision is issued. So, for example, a workers' compensation case, you would need to go through until you have a final decision from the director, from the department, before you can do anything else. And what are we talking about? Well, if you're unhappy with the decision, then you would be able to appeal that to a circuit court, or if you're in federal, to a U.S. district court. But you can't do that till you have gone through the agency procedure. And again, this is because we feel that the agencies have expertise in this area, and so they should be allowed to do their work before the court looks over their shoulder for the most part. Okay, are there exceptions to this? Well, in certain limited instances, the agency may determine that no need to go through the process. We have a good idea what's going to happen, so the agency can give you permission to go ahead with your court suit even if the process is not finished. Now, this is the agency that gets to decide that, and the example I think we used last time was the Equal Employment Opportunities Commission, EEOC, and they can give you a right to sue letter, and this essentially is your ticket to go ahead and file suit without needing to go through the entire agency process. But short of that, you do need to exhaust your remedies. You do need to go through the agency process before you can apply to the courts. Why do courts extend considerable deference to the administrative regulations and decisions? Well, I just hinted at that. It's because we feel that departments and agencies are, in fact, experts in their field. Not surprising when you think about it, because the departments and agencies, many have a fairly defined and narrow focus. They're able to hire people that are experts in that area. They're doing all of their work in that area. They make the rules. They enforce the rules. They interpret the rules. So we would expect that over time they will garner the expertise that's necessary. And so for the most part, the court is going to give deference to that. They're not going to second-guess people that they believe to be experts in this field. So instead, they will be looking to make sure procedures were followed, that sort of thing. Okay, what is the FOIA and what is the Sunshine Act? Well, FOIA is an acronym for Freedom of Information Act. And there are similar open records kinds of rules in most states, Information Practices Act, that sort of thing. And essentially what it does is it says that we are able to find out what the departments and agencies have collected. So there's a lot of records that are put together by the various departments and agencies, and this allows us to see if they've collected information on us or of something of interest to us. Now, there are a fair number of exceptions, particularly with the Patriot Act and some of the things that have happened in response to terrorism. So there are some security provisions, but for the most part, unless it comes within those protected areas, we're able to get information, and you will see frequently that Freedom of Information Act applications have been filed, and the agencies respond. So at one point, the agencies were reticent and had large charges to give you this information, but it's been amended so that they need to give that to you electronically. So it is much more available. Now, the Sunshine Act is another word. Many states use the term Open Meetings Act, and this is similar with respect to what's the oral decision-making, et cetera, that's going on, has a similar idea to the FOIA, so that we know what these agencies are doing. And again, it's particularly important in this area, this branch of government, because there are so many departments and agencies going on. So, of course, it's different from the legislature, which is in session for a set period of time, a lot of news media, et cetera. But with the hundreds of different agencies, we don't necessarily know what's going on unless we're able to have people attend and check out what's going on. Okay, so today we're going to be looking at consumer protection. Now, we've already looked at a number of these sorts of things, but we'll review them again in light of the some additional statutes. But we've talked a little bit about advertising and sales when we looked at UCC. We'll talk about some credit and lending. We've talked some about health and safety when we talked about products, liability, and torts. And then we'll also talk a little bit about landlord and tenant. Okay, now one of the things about consumer law is this is an area where we have adjusted the common law considerably. So we are becoming much more protective of consumers. And part of this is because that products have gotten more complicated. Okay, so again, just because we have a consumer law statute does not mean that the common law or a general statute does not apply. It's just additional protection we've added on. And again, we've talked about this a little bit with sales, and we'll take a look at that again today. Okay, so this is largely going to be statutory law. There are, of course, cases interpreting the law, but there's not a large amount of common law here that has survived. And that's because common law originally had kind of a laissez-faire or take care of yourself kind of attitude. So one of the terms you may have heard would be caveat emptor, and that translates, Latin translates to buyer beware. And we've looked at this a little bit. It's kind of like purchasing something as is, but that was modified even in common law by the idea of fraud, so misrepresenting something affirmatively, and by some warranties. Now, again, these implied warranties have now been taken over by the UCC, so that's covering most of our sales in this area. But we are moved quite far away from the buyer beware, particularly with respect to, as I said, complex products that an average, a reasonable person would not know are dangerous without having instruction, warning, etc. Okay, so the UCC certainly applies. We're talking about sales of products, and so UCC certainly applies. UCC, however, is not directed specifically to consumer transactions. It also involves all commercial transactions. But we, again, are interested in those areas that we've touched on earlier about warranties, unconscionability, that sort of thing. Okay, so what are some of the things we'll be checking out as consumer issues? Well, obviously advertising, product safety, food and drugs, sales, as we mentioned, credit and labeling. So we've touched on a number of these in other regards. So again, there are various media that the sales are going through. We talked a little bit about the internet, and there's obviously other media included. We talked just a tad about labeling and packaging. You recall that the warranty of merchantability had something to say about properly labeled and packaged, but we'll carry that quite a bit farther with some additional statutes. Haven't talked much about credit protection, although when we were talking about banking, we did touch on some protection you have if you lose your credit card. And again, consumer health and safety we looked at when we were talking about torts. So these should be familiar, and we'll just be adding on the additional protections that have come through consumer protection statutes that have been passed federally. And there are, of course, local, state and local equivalents to the majority of these. Okay, so one of the earliest and most important laws was the Federal Trade Commission. So that you can see this is 1914, and it created the Trade Commission, and the goal, the purpose was to prevent unfair and deceptive trade practices, including deceptive advertising. Okay, now deceptive advertising, again, if it rises to the level of fraud, we've already looked at, it is covered. But the unique thing here is now the Federal Trade Commission, again, a very early agency, was given considerable powers to take action about this. So they can issue cease and desist orders with respect to products. And a cease and desist order is the functional equivalent of something we saw when we were talking about the courts. So trying to recollect what was it the court could do to cause somebody to stop doing something. Well, that's the equitable remedy of an injunction. And a cease and desist order is essentially the same thing as an injunction, although issued by a department and agency. The other thing they can do with deceptive advertising is they can require that the manufacturer, if they've been doing deceptive advertising, they can require them to do re-advertising or counter-advertising saying that those were not true. And there's one of the earlier cases had to do with mouthwash that was supposed to kill germs and prevent disease. There was no scientific basis for that, and so subsequently the manufacturer was required to say, contrary to our prior advertising, our product does not do this. So they can require that, affirmatively require that the manufacturer correct past misleading or deceptive advertising. Okay, now puffery we've talked about previously, and something new we'll look at is bait and switch. Now, you recall puffery we talked about when we talked about misrepresentation. So when we were looking at the intentional tort of fraud and misrepresentation, we talked about puffery being the same thing as seller's talk. In other words, saying this motorcycle rides like the wind, or this is the best world famous whatever. So what was the difference between this and the actionable fraud? Well, you recall puffery was an opinion, so it's a generalization. It's not expressing a factual characteristic or something of the product. So this is pretty wide open as long as it's an opinion and it's not a factual misrepresentation. You see this obviously in all the advertising going on, and that is not deceptive. Okay. Now, bait and switch is very clearly deceptive, and it is protected. What do we mean by bait and switch? Well, this is where a seller will kind of put in a come on, something that's an incredible deal, almost an unbelievable deal, that will get you to come to their store or contact in the marketplace. So that's the bait. In other words, you can get yourself an automobile for $89, okay? And so you go down with your $89, and it turns out there are none of them left, okay? And so they say, well, we don't have any of the $89 ones left, but for $980, we got something way, way better that you'd rather have anyway. Okay, so what it is, the bait, that's them drawing you down with something unrealistically good or not available. And the switch is obviously attempting to sell you something different. So there are rules about doing this if there is really no bait. So they have to have a certain number of these products if they're advertising they're available. So you will see limitations where they say 10 at each store, that sort of thing. So obviously the sellers are figured out exactly what they can say and not say and stay within the law. But if clearly they are bringing you down, there's nothing there, the bait isn't there, then they have violated this law. Okay, we talked a little bit when we talked about the internet and what goes on. Obviously, much more of our commerce is happening on the internet, and so these rules all apply there, and they are also adding provisions to make it, to try and cover the technological advances. So if we're going to clearly and conspicuously post qualifying or limiting information, again, we talked about how this may be problematic on the internet, because contrary to a sales contract or information we receive in paper where it's all together and we can read it, remember on the internet it may not all be right above or next to when we click on our agreement, when we accept this particular transaction. So what the statutes say is that there needs to be, if they're putting it in a different place or that may appear to be hiding, they can only do that if there's a reason, if there's a substantial amount of information that wouldn't fit in a clear and conspicuous place. Okay, we talked about there's different forms of sales, so we'll look at some of the regulations in this whole lot of them, so we'll just touch on some of the major regulations that affect the different kinds of sales. So we'll look a little bit at telephone, mail order, information you have not requested, products you have not requested, and finally door-to-door sales. Okay, so telephone sales. Is there anybody who has not received a call at dinner time? Okay, so we have a lot of telephone contact, maybe moving more to the internet and spam and whatever, but still a lot of telephone contact. Of course, the political contact probably isn't going to be covered here, but if they're trying to sell you something, there are some regulations that they need to follow. So with respect to telemarketing, we can no longer have to be concerned with getting these robot calls. So the automatic solicitation with dialing and pre-recorded messages, at least in terms of the commercial side, cannot be done. Another thing is that every time we get new technology, of course, the marketers and whatever will follow. So when we got faxes, many businesses, say around 10 o'clock to noon, were unable to use their fax machines. And why do you suppose that is? Well, because all of the lunch places were faxing menus and invitations to come eat at their place, buy stuff for the rest of the office, etc. So there would be unsolicited faxes inundating your fax machine. So sellers can no longer send you unsolicited faxes. They have to get your permission to send you commercial material over your fax. Okay. Now again, spam area, they're working on trying to figure out how to do the same sort of protections online, but not really, much more difficult, largely because we don't know where a lot of it comes from, as we talked about when we looked at the internet. Okay, so if they do violate this, you do have some protections, cause of action, and even treble damages, which means that if they are willfully contacting you after they know you do not want to be contacted, then they can treble the damages. Okay, there is a do not call list that's been around several years. So if you let a telephone solicitor know that you do not want to be called, they need to remove you from their list, and you can sign up for the federal do not call registry to prevent this kind of contact. Okay, if you receive both telephone and mail orders, because you're not dealing face-to-face, do have provisions for making sure that when they give you a time when things will be shipped, when things will arrive, that sort of thing, that they are held to being truthful in that. If they do not ship on time, then they need to have a timely refund, that sort of thing. Now, in mail order, this has been around quite a while, and if you receive things in the mail that you have not asked for, you do not need to return those. You can do with those as you will. So prior to this, there used to be what they would send things on approval. In other words, you could receive things you had not asked for, and they would say, if you like it, keep it. If not, you need to ship it back to us. So they were able to put the burden on you to do something because it was still their goods. And what this does is if they send it to you unsolicited, you have no obligation to do anything with return it or do anything particular with it. Okay, now finally, door-to-door sales. Now, this is not nearly as common as it used to be, but these sales are singled out because of certain aspects to how they work. But perhaps the more experienced viewers may recall when people did do this door-to-door. And when I've talked to folks, they say these days they may hear from the vacuum cleaner people. It used to be the encyclopedia salesman, but of course people doing that online, not that happening that much. So there are various things that were being sold door-to-door. And the problem is that not only were these great salespeople doing this, but you did have a captive audience when you went to someone's house. It's not like they had voluntarily come to your store. you're there at the door. And these are, many of the homebound people are particularly vulnerable, so they may be elderly, they may have disabilities and otherwise be more vulnerable. And the whole process of having somebody kind of come into your home does not allow comparison shopping, thinking about it, etc. So most states have passed what we call a cooling off period, and this is generally 72 hours. And so both the FTC rules, Federal Trade Commission rules, and state statutes will give a cooling off period for this type of sale, so that after the person has left, the family members talk to you and say, what in the heck did you buy that for? That you do have an opportunity to cancel that sale. Again, this is only for the door-to-door. You can't, doesn't apply if you buy it yourself someplace else. But because of the unique nature of these kinds of sales, this kind of protection is afforded. And you get the best protection, whether it's the state or the feds. And we've talked about that before, where the states can give more protection than the federal statute if they like. Okay, labeling and packaging. Again, we did talk a little bit about this, but it needs to be accurate, easily understood by the ordinary consumer. And the early statutes that had to do with labeling were often industry specific. So it would be for wool, fur products, for things that might be flammable. For many years, they were selling cellophane hula skirts that would go up like a torch. Okay, so these early statutes about labeling were directed mostly to different types of specific types of products. In 1966, we had an act that covered virtually all products, and it requires that we describe what the product is, the quantity of the contents, which now can be in metric, who the manufacturer is, the packager or distributor, and nutritional information if food. Now, we're not going to go deep into this, but there's some information on the website that shows you how complicated some of these regulations are. But it don't, for example, this only applies if your product is a consumer commodity, which means that you consume it or expend it when you use it. So therefore, it would apply, for example, to aluminum foil, candles, light bulbs, which get used up, but it would not apply to toys, hardware, or sporting stuff, which does not get used up, or motor oil, although it gets used up, it's not in the household. Number of other things were excluded here: meats, poultry, tobacco, drugs, alcoholic beverages, that sort of thing. And it only applies to packaging that the consumer gets, so it doesn't apply if the retailer receives it in a packaging and then separates it and sells it differently, then this would not apply to that. Okay. Since then, there have been many additions on labeling. So tobacco, you're aware of. The Nutrition Labeling and Education Act 1990, again, a major advance, and this is what we now see on all of our food products. This is a very active area, so there's debates going on continually about whether or not it applies to certain dietary supplements and that sort of thing. So many industries are concerned about how much they have to put, etc. And then there is the question of whether or not a particular vitamin or whatever is a food or a drug. And we'll be talking about health and safety down the road. So that if the Food and Drug Administration gets involved, there's the question of which this is. So again, you've seen these types of labels, and you probably noticed that it changed over the last few years because there are additional types of information that consumers now want. So what's the big one in the last couple of years? Trans fat. So there may be, will obviously be changes as we go along as to what kinds of information consumers want. And we're constantly tweaking this to make sure that the information is a usable form and people can understand it. So you can see we've looked at serving size and that sort of thing, percentages, so that people have some idea of what they're getting. Okay, another large area of interest to consumers in an area that is increasingly being looked at is the credit area. So your ability to get credit to make major purchases, etc. There have been some, you can see there's a string of acts here starting in the 60s. And again, this is a very active area where changes happen. When we started using credit cards, we had some more changes that applied. Now that we're doing much things online, there'll be some additional changes there. So again, another active area where lots of rules and regulations are being issued. Now, most of these acts came because of a certain kinds of problems, specific problems that we were trying to correct. So, for example, for many years, women had trouble getting credit because they were generally based the credit on perhaps a working husband, particularly if they were not working. So there's some issues there. Very unfair collection practices when people were not able to pay, so there were very abusive types of collection going on. And of course, the keeping of records, the reports on credit were not done in what was considered to be a fair way. So people would have bad credit history, maybe or maybe not deserved, and could not correct that if there had been a mistake. So that's why we have a whole lot of regulations in this area, because this was an area where there seemed to be some abuses and some unfair practices going on. So you can see we have quite a number of laws looking at that. Okay, one of the most basic is Truth in Lending Act. So this was a major provision of Consumer Credit Act, and this is basically a disclosure law. So it tells us what the added costs are if we're paying in installments, and it requires everybody to compute this the same way so that you will have an idea what is you're paying. Okay, so they need to tell you what the amount is that is being financed if you're buying on time, and they need to tell you what the finance charge is in the total. And you probably can't see this, but again, on a major purchase such as a car or a house, it's somewhat daunting when you see how much you are paying for that credit. So on this particular item, the amount being financed looks like $73,000. $97,000. The finance charge is $73,000, and so the total payments will be $151,000. So you can see the finance charge is virtually ends up over time being over half as much again. So this does need to be clearly posted so that you know what it is you're paying for the benefit of paying over time. Okay, so there are some serious penalties for this, and again, this is an area where the charges can be doubled, and there's also costs and attorney's fees involved. Okay, the equal credit opportunity we mentioned extends the credit to people, women, minorities, anyone, and so you cannot be denied credit based on one of these protected classes, same as we looked at when we were talking about employment. Okay, so fair credit reporting protects us in the credit records that we have. So we do have access to the information about us. If there's something unverifiable, that needs to be eliminated, so we have the opportunity to find out what our credit report is and question if there's a problem there. If we find something we don't like, then they have to change it. And you can get your credit report from each of the major agencies for free. So there's information on the website about how you can get a copy of your credit report once each year from the three major credit reporting agencies. You don't need to go through the advertised private firms which are either trying to hook you in or otherwise, but you can receive it directly from the credit agency. So you may want to do that rather than use a commercial source where they're trying to sell you something or get you on the hook for something. Okay, so debt collection. Again, this was an area where there was some abusive practices going on, and so we have limited that. Now, what kind of abusive practices? Well, calling your employer, calling all hours of the day and night, that sort of thing. So that is prohibited. So they cannot harass you, they cannot threaten you, they cannot call third parties about you. There are, of course, we're simplifying this, some exceptions. If they could call your home, and there may be other people there, but they cannot communicate with you at work if you ask them not to. And once you tell them that you've got the information, don't call, there's some limitations. They can't keep hounding you, so to speak. So there are some protections so that the collection process can be persistent but not unfair or harassing. Okay. Okay, equal credit we covered. The part here that I hadn't mentioned was that a female can open a account in their maiden name if they want to be sure that in the event of not being with their spouse that they have credit, so they can establish their own credit. And of course this would be particularly important if we have a non-working spouse. Okay. They cannot ask about birth control practices, intent. So in essence, there should be only three reasons that they're denying credit that would be fair reasons: low income, large current debts, or poor record of payments in the past. Okay, well, we're going to move into the health and safety area. So the FDA is going to be our major agency here, the Food and Drug Administration, and it will cover food, drugs, and cosmetics. So this is a massive area. As we talked about earlier, there are some distinctions between whether something's considered to be a food or a drug. So if we get in the vitamin area or the supplement area, we may be concerned whether or not it's a food or a drug. But this is a giant area, and so there are many, many regulations. It does make a difference to some whether or not you are food or a drug. Obviously, drugs are much more carefully regulated. So the Pure Food and Drugs Act, very early act as well, you can see in the 1900s. And it's been modified many, many times and added to. Protects people against adulterated foods, misbranded, and it is, as I said, done by the FDA. Okay, the Consumer Product Safety Act in 1972 covers a lot of products, and we've talked about products liability from the respect of simply torts, but it created the Consumer Product Safety Commission and has broad regulation over safety of consumer products. And again, we will define what a consumer product is, but it's fairly obvious types of things that could go directly to the consumer. We talked about, when we talked about torts, about the warnings that are required, but the Consumer Product Safety Commission has broad powers to recall. So you've seen a number of recalls that we have seen with automobiles and other types of consumer products that's found to be a defect or something that isn't safe, and so they can implement those to let consumers know that there are problems with this particular product. We've seen other things, for example, with cribs, that sort of thing. Now, a certain time of year, we're going to see an awful lot of these. What time of year? Well, when it gets to be Christmas time, you'll see many, many of these warnings and that sort of thing that will come out with respect to children's toys. So over the past few years, we've had problems with perhaps lead paint. We've had problems with the kind of recurring problems with pieces that will come off toys that can be swallowed by younger children who tend to put anything and everything in their mouth, that sort of thing. So again, Consumer Product Safety Commission will be issuing a lot of warnings throughout the year, but particularly Christmas time when this type of thing, when many more toys and that sort of things are purchased. Okay, I want to move a little bit now to the real property area simply because we want to give you a little background in the landlord-tenant. So this is an area that many of you will be involved in, and so there are a lot of other statutes involved with if you're purchasing a home or other real property actions. So there's fair housing, which again would protect you if you were being discriminated against on one of the protected categories, such as race, religion, gender. In Hawaii, we also include marital status. Okay, so that would be an additional protection that's not federal but is involved in the state. So again, you always want to look at your state protections. But again, in buying and selling of property, there are these other statutes, and there is material on the website if that's of interest to you. But we want to focus in on landlord and tenant. But to do that, we need to make a distinction. You can see here between real property and personal property. So we've talked about personal property being goods, and when we talked about collateral, made the distinction between tangible sorts of things. Real property, of course, is the land. It's the buildings on the land, and it's the fixtures, so the things that are attached to the land that cannot be removed without damaging it. So that would be your rock wall, etc. Also, the vegetation, etc. Whole area about mineral rights and air rights, etc., that we won't get into, covered by real property. Okay, so your ownership interest can be possessory, and that simply means that it is, for all intents and purposes, yours. So it can be either yours in fee simple, which we'll talk about. You can have it for a life interest, which means that you have it until you die, and then it goes another place. Or you can have a leasehold interest, and that's going to be landlord-tenant, so that's going to be lessor, lessee, that we'll talk about in a minute. Now, there are other kinds of rights to property that are more, shall we say, transitory, and so that's an easement. So you may be, someone may have an easement to cross your property to get to the beach, or cross your property. They can have a utility. The only way to get to their property is to have a utility line go across your property, that sort of thing. So those are non-possessory interests as well. But the lease that we'll be talking about is a possessory interest that gives you interest in possessing that property as a tenant. Okay, now I want to distinguish between fee simple, which gives the owner total rights, so to speak, and leasehold, which means that you have it for a period of time. Now, I should note here that with respect to residential property, Hawaii is one of the few places that has a fair amount of leasehold property. So most states, if you buy residential property to live on, you're almost for certain going to be buying fee simple. In other words, you are the owner of the property, the land, your home, etc. Only Hawaii and Maryland have a substantial amount of property that is leasehold, which means you own your home, but you don't own the land that it's on. So a lot of people will start out with leasehold, but will want to move to fee simple where you own both your home and the land under it. Leasehold is less expensive, as you would imagine, but the problem may be at the end of the lease period, the lease rent could be changed. So even if you have a longer lease, 70, 90 years, at the end of that period, you or your heirs could have a concern that the lease rent would go up substantially, perhaps where you couldn't pay it. So Hawaii had, for many years, has had the ability to cause owners to sell the underlying leasehold interest to the the tenants so that they are now owning in fee simple. And actually, the City and County of Honolulu had that same provision for condominium owners. That's now passed, but allowed the people to buy the fee interest. Okay, so let's look at landlord-tenant. And again, the landlord is also the lessor, and the tenant is the lessee. But in terms of residential property, we use the term landlord-tenant. Now, we will be talking specifically about residential landlord-tenant because that's where you will be living. Obviously, we have leases, much more common in the business area where businesses would lease property. But we're going to concentrate on the residential side. Okay, so what do we have when we get a lease? Well, we have temporary right to exclusively possess the property. And what does that mean, exclusively possess? Well, we have certain rights that we get provided by both by common law and by local statute. And many of the statutes, including Hawaii, are based on the Uniform Residential Landlord Tenant Act. So we have looked at uniform acts in the past. It means that we can modify them in our state, but they have a lot of similar provisions to what the Uniform Proposed Act was. And you'll recall that the Uniform Acts come often from an NACUSL, National Conference of Commissioners on Uniform State Laws. Gives us a lot of background for interpreting how that works. Okay, so there are a lot of common law that is involved in our landlord-tenant. So there is the right to quiet enjoyment, which means what? It means that the landlord cannot come onto our property anytime they want. They have given that property to us for that set period of time as long as we're complying with the law and the agreement. Now, they may have certain rights to come on and make sure things are okay for an emergency, that sort of thing, but they have given up that right to you for ownership for that period of time. You are now the owner, in essence, of that property. So there are various warranties they're giving you as the landlord. Another one that's important is the warranty of habitability. So in general, they have to give you a property that you can inhabit, that is safe and healthy and does not have any defects that would cause it to be not able to live there. So that's another warranty that they are giving, is that it is a habitable place. Okay. So again, these are common law warranties, but they're also, we have changed them obviously with the Uniform Act, the Landlord-Tenant Act that we have mentioned. Okay, so what are the basic provisions for in ULTA? Well, it's the whole idea here is to standardize the process by which we can evict people from the area. So if the tenancy is over, you haven't paid rent, etc., and they need to get the property back, we have some provisions for that. And this is obviously a very contentious time if this is a place you've been living in. We call that process of getting rid of the tenant, of securing the property back, as eviction. And many places also call it summary possession. So we are trying to get possession of the property back, and summary means the idea being that we're making that reasonably short and sweet. Okay. If there is a concern about whether the rent is due or has been paid, or whether the tenant does not have to pay because of something the landlord has done, then there would be provisions that payment would go into the court, and then the court will decide whether it should go back to the tenant or to the landlord. And another final area that's been very problematic in the landlord-tenant area is the security deposit. So the security deposit is the money you pay upfront, usually a month's rent, and the purpose of that is to secure damages to the property. So the idea being with a security deposit is that if after you leave there have been damages you caused to the property, that would be money the landlord has to make repairs or to correct whatever damage was done to the property. So these are kind of the major areas that have been contentious in landlord-tenant relations, and that's what the uniform law and, as I said, Hawaii follows closely. was meant to correct. So, what are the provisions? Certain minimal conditions of habitability, penalties for breach of the provisions, and these are, as I said, these kind of mirror what happened with the common law as to what habitability is, but it does provide the penalties if either landlord or tenant breaches, so it kind of formalizes this. Should mention also that many of these provisions are very similar to a model code that was promoted by the American Bar Association Foundation. So again, these are provisions similar to this have been enacted in most states. I think there's one state that does not have a residential landlord-tenant code. Seems like maybe Wyoming, but most states have something very similar. Okay, so what are the landlord's duties? Okay, comply with building and housing codes, keep premises fit and habitable. Again, we've talked about that. Keep the common areas clean and safe, and provide water, waste receptacles, heat, etc. So again, all of these have to do with making this habitable. Now, the rental agreements, the lease agreements, can make various provisions for who is supposed to do repairs and that sort of thing, but in general, you would be expected to provide running water, etc., heat. Not a problem in Hawaii, obviously, but in most parts of the country, you would be required to have the ability to provide those to the tenant. And if you didn't, then you were not providing a habitable premises, and you might not be entitled to your rent at that time, and the tenant might have remedies to cause you to bring it up to a habitable condition. What are the tenant duties? Well, you can figure them out early. First one, pay rent when due. Again, tenant needs to can be reasonable and not damage the property. Again, comply with things for getting rid of the trash, waste, etc. And common law again provides that they are not to bother their neighbors. In other words, so to conduct themselves so that they are not disturbing their neighbors. This is common law. It's in many state statutes. It's actually not in Hawaii's, but we do have the common law requirement. Okay, now again, eviction was an area we talked about which is problematic. And what we mean by eviction is that the landlord is depriving the tenant of the property. So they are locking out the tenant or taking the property back. So constructive eviction means that the landlord has done something that causes the tenant to leave even though they haven't thrown them out. So, for example, if the premises are so bad, infested with vermin, or the water stops or flooded or something, and the landlord doesn't do repairs that they are supposed to do, that's constructively evicted. They've caused the tenant to leave. Another type of eviction that's protected is what we call retaliatory eviction. So if the tenant reports that the landlord has let the premises get into an uninhabitable condition or otherwise is violating the codes, then and then the landlord evicts them, that's retaliation, and this is kind of like the whistleblowing. That's prohibited as well. Okay, so that's given you kind of a quick and dirty on landlord-tenant. Again, brought that up because most of us will be involved in that on one side or the other or both. Again, additional materials specifically about Hawaii's landlord-tenant code are online, so please take a look at the materials we have online, and you will see quite a bit of additional information. Again, the whole consumer protection area is very broad. We have our own Office of Consumer Protection, which is part of the Department of Commerce and Consumer Affairs. Again, a lot more information for you on that. Okay, well, we have covered the regulatory area and some items I hope were of interest to you both personally and in your business area. And we're going to be wrapping up by talking about international law, where we fit into that, and so that will kind of bring us to the end. And so I will see you next time. Aloha. This is Ben Carroll.